Okay, welcome everyone. It is 10:30, so I hope everybody who needed it had a chance to get a cookie and a coffee to get them all energized for this next session. So welcome to this, this panel on implementing AI governance, lessons from regulated sectors. So in this panel, what we want to do is to obviously recognize that a lot of new regulations in this digital sector have been passed over the last year and a bit. The AI Act is about to come into force, that is to say, to be published. You won't have to comply with various of the parts immediately. But of course, a text is only a text until it gets implemented. And really, the value and the success of any piece of new legislation, like the AI Act, is going to be judged on how it is being implemented, how successful it's going to be. And the same is true for things like guidelines and commitments and other kinds of AI governance mechanisms that have been explored in various types of jurisdictions. So what we want to do is to reflect a bit on this question of how do you get to successful implementation, or also where are some of the areas where implementation in other sectors where regulation already has existed for a while may have stumbled. And what can we learn from that when thinking about AI governance and AI regulation? On my panel, I'll be asking each of them to introduce themselves. We have Olga Litvinets from EY. I myself am also from EY. Ashley Kasfan from the IAPP. Susan Scott Parker from Disability Ethical AI. And Sebastian Hallensleben from VDE, who's joining us virtually. He'll be showing up in a second. So I myself at EY am the Global AI Ethics and Regulatory Leader, part of the Global Public Policy team, where we've been focusing on the public policy developments, the new developments and regulations in the EU, but also outside of the EU, and questions around how to make sure that these will be effective in the way in which they get implemented, part of that being how to make sure that they are interoperable between different jurisdictions, such that if an organization puts in place something to be successfully implemented in one jurisdiction, that it will also work in other jurisdictions. An element to that is obviously the reference to technology standards, which I've seen there are a couple of activities around that at this conference. There's a panel just after this one, and there's a workshop that we'll be running after lunch. Hope that you can join us there as well. So with that, I'll hand over first to Olga for a short introduction.
Thank you very much, Ansgar. Good morning, dear colleagues, esteemed attendees. Olga Litvinets. I'm working at EY at Risk Consulting, and focused around topics of responsible AI and the risk we are challenging with artificial intelligence. This topic is something I'm passionate about because it was a subject of my PhD, and I was working before EY at Carnegie Council of Ethics and International Affairs, and also at the United Nations on the analysis of lethal autonomous weapons conventions.
Thank you. Ashley?
Thank you, Ansgar. Thank you, everybody. It's really a pleasure to be here. Ashley Kasfan, I am the Managing Director of IAPP's AI Governance Center. Many of you probably are very familiar with IAPP as a privacy professional association. We have, as of last year, expanded into AI governance, and I will share my background in a moment, but suffice to say that there was a need to bring on some expertise from an AI governance perspective, and now I'm very interested in this intersection of privacy, AI governance, and other types of digital governance which I think that we'll cover in our discussion today. I come to this work, I was previously the executive director of the Responsible AI Institute. In that capacity, I had the opportunity to work with the likes of VDE, but also national standards bodies, including Standards Council of Canada, where I still remain the co-chair of the Data and AI Standards Collaborative. The work of Responsible AI Institute was really to understand the different types of standards and certifications that are needed for the oversight of AI systems. I was quite interested in looking at the different types of technical needs that we have, and again, I think we'll get into this as part of a robust governance program that's needed. And I came to that work where I was the Director of Data and Digital for the Government of Canada, where we developed the Directive on Automated Decision-Making Systems starting in 2018. And so I've been in this space for quite some time, really looking at what the key implementation tenets for AI governance are.
Thank you. Susan?
Hello, I'm Susan Scott Parker. I founded the first business disability network, the one in the UK, and I'm a strategic advisor to the ILO's Global Business Disability Network, helping companies get their act together on disability in various networks around the world. We set the first standard ever measure of corporates' disability performance across the business back in 2005. And I recently helped the ILO to set up a benchmark, if you like, that's viable, sensible in any jurisdiction. And what else is relevant? Disability ethical AI, as Ansgar said, is actually disability ethical (AI), because we were set up to try to bring the reality of disability-related discrimination into the debate about ethical and responsible AI. And I'll just leave it there.
Thank you. And over to Sebastian online.
Thank you very much, Ansgar, and thank you for making remote participation possible.
Can we get the sound?
You need some AI assistance.
Let's see. Yeah, you let me know as soon as you can hear me.
I vaguely hear something. Can we get the volume up?
Can you? I'm just speaking to make sure you've got something to play with in the
I can hear you
technical
a little
team.
bit, but it's very soft.
No, we can't hear.
Can we increase the
So,
volume, please, for
yeah.
Sebastian, for us to hear?
I'll just keep speaking so you've got something to play with in the technical team as far as my volume is concerned.
Sebastian, I think the problem's in the room because you're still very, very soft, and I think you're already shouting.
Yes, I am actually. Yes. I'm not sure. There must be a dial somewhere that can be turned up.
We've got an AV person coming.
Oh, great. Super.
Basics straight before we moved on.
That looks like something's happening. So I really hope that we're getting there. And I'll just keep talking, and you shout as soon as I'm loud enough. So hopefully we'll get there.
We're still not properly hearing you. The AV guy just ran out the room to try and do some kind of fixing. In the interest of time, I suggest that we move to the first opening remarks, and then we'll come back to you as soon as we have the opportunity to do so. Thank you.
Sounds good.
So to start with, for our opening remarks, going into the topic a bit more clearly, I'd like to invite Susan to speak. She'll be talking about disability regulations are something that we've had for quite a while, but now where have they succeeded and where have they not succeeded?
Thank you. Actually, I was very pleased to be asked to join you today because Ansgar was talking about can we learn from experience? And I just wanted to point out that after all, Asimov introduced that first law, remember, do no harm. That was back in 1942. So while my experience doesn't go back quite that far, I just wanted to say it is grounded in being actively involved in monitoring and trying to influence and helping companies to comply with a whole range of standards and disability-related legislation, accessibility, technical standards, benchmarks, maturity models. The list goes on and on. And of course, lately it's been attempting to address the woeful lack of consideration in the debate around ethical and responsible AI of the impact of this technology on people with disabilities. What I've learned, well, it's one thing to have a standard or a piece of legislation or a regulation that's fit for purpose, but what about the regulator? What does a high-performance regulator actually look like? What do they deliver? And when is the problem not the standard, but actually the regulator? Regulators need to understand that a standard, and when I say standard, I'm going to mean regulations, whatever we're putting in place that's trying to address this. They need to understand that the standard is a tool, not the solution. To really simplify, the job is of a regulator to take that tool and try to make the world a better place, because presumably that's why it was needed. Tending the regulation, but not changing the complex system that triggered the need for that regulation isn't good enough. They must at least attempt to drive change on the broader frame or ensure that somebody does. And it may seem to be a bit odd to say this, but regulators need to really believe that their regulations matter. Believe that they will make this world better if those regulators do their job well. However, for example, we see very few equality and human rights bodies around the world who seem to really believe that the disability regulations, for which they're responsible now, are to do with human and employment and consumer rights, just like race and gender is to do with rights. Hands up if you've ever seen a high-profile campaign from your national human rights body telling employers that people with disabilities in work are entitled to reasonable accommodations as a right. I was going to pause and wait for the hands to go up, but I haven't seen that in the UK, where that right has been there since 1994. So to put it bluntly, regulators need to regulate. Now consider, as evidence, if you like, the recent American government research. They focused on their own performance in terms of compliance with Section 508 of their Rehab Act, which since 1998, I stress 1998, requires government to be accessible in terms of their use of technology for the 1 in 4 Americans with disabilities. So they looked at, the websites, the documents, all the indicators, and found that there was a fewer than 30% compliance rate. So 71% in effect non-compliance. Now I interpret that as people working in the Department of Justice, which is, I wanted to also add, because in addition to the non-compliance, listen to this bit, the government report says that their own Department of Justice has not issued its legally required biannual report on this Section 508 since 2012. So what we have is, I think, people working in the Department of Justice who either don't believe that this matters, who don't actually like 508 for some reason, or who have not been permitted to write that report. Have the politicians somehow intervened? Nobody knows. But clearly, no one is regulating the regulator. I asked a distinguished accessibility expert how he would explain the 70% failure, and he said instantly, nobody cares. Well, how do you determine if a regulator cares? And how would you, if there are people in the room who are regulators, are any regulators in the room? Hands up, regulators? One. Oh, well, we'll get your name later, sir. How would you have regulated so that the regulators regulate? And I'm really not being facetious here. Coming back, what are the key performance indicators for a high-performing regulator? We see some indicators from some equality bodies that they regard society as somehow becoming more fair, more equal. But very few actually have regulators that look at their own performance as a regulator, that look at the quality of the support they provide to individuals who claim that they have been harmed, who look at the quality of its messaging, the quality of the way in which it attempts to leverage its leadership and influence. Because, of course, regulators mustn't just understand the societal problem their regulations address. They must be crystal clear who in particular needs to do what in particular, if that problem is to be solved, if we can use the word solved. We don't need vague calls for compliance, or my favorite, of course, is you must be inclusive. What we need is a message from regulators that says these actors need to do this, and we can tell you how. And of course, one of those key actors is procurement. I want to come back to that in just a moment. Regulators must not only have teeth, they must be seen to have teeth, and a few carrots. The teeth and carrots thing I wanted to play with, but I don't know what to do with it. They need the leadership will to use those teeth and the wisdom to know when, and they need to know what to watch for, because their monitoring role here is crucial. How will we, for example, stop discrimination against job seekers with disabilities if the regulators fail to monitor the automated processes with AI all the way through that now routinely discard people with facial disfigurement and so many others? Because the individuals, of course, have no way of knowing that they were harmed by an algorithm and that their life chances have been reduced as a result. So reliant on individuals to take you to court, how is that going to work? So what do high-performance regulators do? Well, if I had one critical success factor, what they do is they change the behavior of procurement. They will fail, whoever the they are in your world. They will fail unless procurement stops buying the stuff, stops buying the products and services that fail to meet whatever standards the regulators put in place. Procurement talk about the red line. Unless this supplier does that, we won't buy. We don't see any red lines yet out there on the accessibility domain, and those regulations have been around the world for years. If their behavior doesn't change, procurement, whatever regulators say and do isn't going to get us where we want to go. So let's focus on that one key indicator and see where all the deliberations of this major conference are taking us. So in summary, and it seems so weird to have to say this, we need regulators who regulate. Is that too much to ask for? And we need the standards for regulator performance to be as robust and explicit as the technical standards they are obliged to be responsible for. And I don't know who is developing those standards, but I'd love to chat. Thank you very much.
Thank you, Susan. So then I'd like to go over to Ashley, reaching back a little bit in your past as someone who's also been involved in some of the work that governments have been doing around procurement and AI impact assessment requirements around procurement. If you could perhaps say some words on that.
Yeah, I'm really happy to. My journey around AI governance definitely started when we were asked within the Government of Canada to, maybe just a bit of history. Treasury Board Secretariat develops management policy for the government. So what we did was akin to what you've seeing now with the AI executive order in the US. It's rules for the government's use of AI systems. And at this time, though, being a central agency, we were fielding a lot of different questions from all departments across the organization. And these are departments that deal with providing benefits to Canadians, to making sure that people are able to get access to student visas, that are thinking about ways to advance or expedite immigration processes, and then a whole host of things like train derailments or helping to help people on helplines. So really running the gamut of different types of services that both governments and companies provide. And so in this, we got access to many, many use cases. And that was happening internally, but also what was happening at a political level was Canada was having a back-to-back G7 chairmanship with France. And so there were a lot of discussions related to some of the challenges that Susan's discussing kind of internationally at the time, related to what are the different types of principles now that AI systems are becoming something that are being adopted, not just by governments, but by organizations, that we should really put some of these safeguards around. And that back-to-back chairmanship ended up in what is now the Global Partnership on AI. And I think there was also digital government work that was going on, and through that, we were able to develop a set of principles that really led to what our boundaries were for how we thought that AI should be governed or used appropriately within the Canadian context. And that resulted ultimately in the Directive on Automated Decision-Making Systems. As Ansgar mentioned, one key component of that is the algorithmic impact assessment, which I promise I'll get to your answer in a second. But I think what's important to know is that we were really then focused on, okay, we are sitting at this intersection of being able to really comment on things like the OECD principles, which were not in existence at the time, and are now guiding a lot of all of our work really in this space. So being able to contribute at that level, but that's a very, very high international level, whereas we also had people, as I said, coming to us from these various different departments saying, okay, I'm the engineer that's being asked to implement this system that we've purchased, and I don't know what questions to ask my vendor, or I've signed a code of conduct as a public servant. I promise I'm super ethical, and so do I really need to follow these rules that you're now trying to put on top of that? We had to have many hard conversations that, yes, you're probably very ethical, but your ethics are not the same as everybody else's ethics, so we just need to put some checks and balances in place. But what that provided me with was a perspective on what practitioner realities are when actually implementing AI governance, and that tension between how do we achieve these lofty, big, internationally agreed upon objectives while really thinking about the day-to-day practices of not just the engineers, but the product owners, the people that are setting up procurement policy, the people that are doing communications for these various different services. So that is the perspective that we brought when drafting the directive, and it was not only one of the first of its kind, but probably the first to set these rules for also recognizing that AI is not one thing, and therefore we need to really calculate the different types of risks that are attributed and focus on from these systems, and then focus on high-risk systems, which now we all know because this is very common with legislation like the EU AI Act. But at the time, it was a novel concept that we wouldn't just cover all types of AI. And so we really had to think through then how we assess what that risk is, and so then we can set the appropriate rules for the actions to be taken to mitigate those risks. And so that's where the algorithmic impact assessment came from. I know that now there are many different concepts of what an AIA is, even if you look, or different types of assessments, how it is used in the Canadian context, or for the directive specifically, is really just to determine, is it high or low risk? There's actually 4 types, but you get the idea. So from that perspective, then we really tried to be as flexible as possible, recognizing that these are yet additional rules onto pre-existing processes that people already have that can be very burdensome. And I think to some of the point that Susan's making, or Susan made already, is that some of those processes, I think we were really trying to think through what are the existing governance practices that we can just augment to support some of those, again, objectives, while still ensuring that people, Canadians, are not being harmed by the systems that we're putting out into through the various different service channels that we have. So from that perspective, I think that now we've seen how algorithmic impact assessments could just be a way to start to identify what are the different types of harms that can exist from a system. While that's very important, I think that confusing all of these things, we probably need to go back to some common set of definitions and understand how we're doing both of those. And I know we'll get into more of a conversation related to governance objectives overall, but a couple things I'd like to share outside of the assessment is how, if you're getting started with developing a governance process, that I often think through this, and again, through that practitioner lens, is thinking about standards have been mentioned, and I think standards are a fundamental way in order for us to achieve some of these objectives. You have to think about standards in terms of the standards that you need for your organization. So what are the different types of processes that need to exist, governance review boards, et cetera. Then you need technical or system-specific standards. So again, AI not being one thing, there's going to be various different standards that are going to be needed for the oversight. And then you need the people to have a certain degree of competency that are going to either have the requirement to be the engineers on those systems or that are even just overseeing that governance process. And hopefully we'll be able to get into that a little bit more. But I think that just to conclude, really understanding first and foremost what your AI system is, what are you actually dealing with? First, understanding the harms or risks or impacts that occur from those systems is the very, very first place to start. Then you can develop or put in place the appropriate mitigation measures that do exist, hopefully being developed from those standards. And then identify I really liked, Susan, what you said, who needs to do what. Identify the who and the what that needs to be done, and put some of those accountability structures into place. And then finally, think through then what your reporting structures are. And this is both publicly and internally. And I hope we'll have time for a conversation about third-party review processes and audits, but that's inclusive of those types of processes. And then just to conclude with the Canadian piece is the algorithmic impact assessment for purposes of achieving some of the transparency objectives that we baked into the directive. You can actually see the algorithmic impact assessments that the departments are needing to do to identify what types of AI they're using, and as a result of what I was mentioning before, and be made available publicly through the Open Government portal. So we were really trying to leverage all of the different types of tools at our disposal and create those different types of implementation requirements to achieve the AI governance objectives that we had set forth.
Thank you very much. And it's great to hear these kinds of insights into also the type of work that I guess the AI office is going to be have to be doing now to provide those types of more detailed guidelines on, so, okay, we've got the high-level regulation, but what exactly do I need to do? What are the things that I need to be checking against? That was sort of the view from on the government side, somewhat. So I'd like to now hand over to Olga to give a little bit the view from companies and other organizations that, of course, are looking at this and saying, okay, so what do I need to do? How do I get ready for this? And which is the space that you work in.
Yeah, thank you very much, Ansgar. And also, I would like to touch the important topic of supply chains and AI, because this is for sure that supply chains and more use AI, and it can enable us to optimize a lot of things and helping organizations to make smarter decisions faster. From inventory optimization to critical storage prioritization, we can make better KPIs. But with all these amazing opportunities, we come with risk, and we need to adapt our risk practices accordingly to this. So as we incorporate AI into our supply chain models, we need to adapt our strategies, and we need to do that for four main reasons. First, it's like, of course, we have a new legislation which is European AI Act, but also worldwide. This legislation is coming, and also our work probably as in risk or like in general in audits, it will be to map all these legislations, all these practices, all these standards, frameworks together and make benchmark and make gap analysis of this. Because of course, the client, the organization, they should be compliant. And in the case of AI Act, they will not want to pay 7% of world turnover, which is like 36 million in case of non-compliance. This is already it start to be easier to explain why we need to implement responsible AI into the organizations. Second is like it's going beyond the legislation, because the legislation it takes time to adapt. We are still waiting for something tangible about the AI Act, for example. But we have ethics, and ethics can cover the gray zone, which are not covered by legislation yet, but it can have some risk in the future, and we can anticipate those risks by already thinking now what can go wrong in the future. So third is basically how we cover all these brand reputation scandals and the cancel culture, and when our customers can lose the loyalty to the brand forever because we did not anticipate something which I was talking before about. And the fourth is how do we innovate with responsibility, because from my experience, even like I had questions from clients. They wanted to implement something like with AI, like even like some large language models or so on. But they weren't sure that how we can actually already do that responsibly and like to be compliant, and how do we do that? So it's also a way to increase the business opportunities, but still do responsible things and safe. So, like now, how practically we can access it? We have a legislation, we have European AI Act. And when we read it, it's kind of challenging to understand what practically we can do. I don't know how many of you read the text here. Really? You agree? Yeah, not bad. You agree that actually you read it and okay, there's like, we need a documentation, we need a human oversight, we need like the robustness, security, transparency, but what practically how we can access that? And in risk, we access it through impact analysis, as Ashley just mentioned, risk assessment, risk assessment. It's all the story. How do we translate requirements from these complicated documents for lawyers to something very practical as controls? And how do we implement those controls? And what are the document requirements needed to provide to be compliant? And how, after we create all this map of controls, how do we create recommendations, roadmap to provide with something very concrete? So, an AI Act, there's already, this is also a risk-based approach. We have the level of risk, and according to the level of risk, also we can proceed. We have an acceptable risk, high risk, medium risk, and low risk. And for like unacceptable risk, we don't develop those systems because they can violate directly the human rights. So most of requirements are concerned about high-risk systems. And for high-risk systems, also for third parties, there are requirements and there are differences between different stakeholders. We have providers, deployers, importers, and distributors. And all of them have different roles in AI supply chain, and the requirements will be not the same for them. So,
okay.
that's all.
Thank you very much. You mentioned, amongst other things, supply chains and the obligations within the AI Act to meet certain kinds of requirements, but that those requirements are not really described in a kind of technical kind of level of detail. This is obviously the role that the harmonized standards are supposed to play within the AI Act. And technical standards more generally when we think about supply chains, also if it's not just purely about compliance with a law, are there to help across the supply chain that you can get confidence in the quality of systems that are being provided from people earlier in the chain. Now, this is very much the kind of space that VDE and Sebastian Hallensleben especially, since he also chairs the Sensenac JTC 21 working group that is creating the harmonized standards for the AI Act, is an absolute expert in. So hoping the technology will support us in here, handing over to Sebastian.
Yeah, thank you again, and hope everyone can hear me. Great, awesome. Yes, so just to catch up on the brief introduction, my name is Sebastian Hallensleben. I'm in charge of digital strategy, AI, and digital trust at VDE, the largest technology organization in the EU. But more pertinent to this session, I'm indeed chairing the committee at Senelec that is creating the harmonized standards for the AI Act. And I've got a vaguely similar role at the international level, co-chairing the OECD expert group on AI risk and accountability, and maybe we'll touch on that later as well. So I've got the luxury of being able to build on the interventions from Susan, Ashley, and Olga. I'd just like to pick up exactly where Olga left off, because you already described the big problem in that regulation such as the AI Act is very, very high level. It might call for transparency, for record keeping, for quality management, but it doesn't really say what transparency is or how to measure it or how to achieve it. And this is not an oversight. This is not because the legislators couldn't be bothered. This is actually by design and follows an approach that has been common at the European level for more than 40 years. It is still called the new legislative framework, even though it has been around for several decades. But this framework essentially lays out a synergy between regulation and standardization. It fundamentally says that regulation formulates the high-level objectives, the high-level requirements, such as transparency, quality management, record keeping in the case of the AI Act. And it is standardization that provides the details. And there is a kind of deal between regulation and standardization. On one hand, regulation says, well, we really rely on standards. Standards are really, really crucial. And therefore, we publish certain standards, the so-called harmonized standards, alongside regulation. And we give those harmonized standards a certain special status in that they come with the presumption of conformity. So that means when you follow those standards, you're assumed to be in compliance with regulation. And in turn, the standardization organizations at the European level kind of give up their usual pure bottom-up approach, where it's individual experts, individual national committees that have ideas on what to standardize, and in return they follow almost like a list of requests, standardization requests from the European Commission, which standards are being needed for the AI Act. And that synergy has worked well in many other fields and is being used again for AI. And so the core of the work, about 80% of the work in JTC 21, is actually in response to this standardization request, creating the harmonized standards to support the AI Act. Now, what does it mean from a company perspective? it has a number of advantages. First of all, following harmonized standards creates legal certainty. Because of this presumption of conformity, it is pretty much impossible for companies to be held non-compliant against the regulation as long as they follow harmonized standards. There are some edge cases, but for all practical purposes, that presumption of conformity creates legal certainty. Also, it creates interoperability in the markets, because you know, or you can assume that your suppliers and also your clients will also know and follow and use those harmonized standards. And therefore, it makes those market business interfaces a lot simpler. I'm often being asked about the timing. And this is one of the really crucial bits, because now that the AI Act has taken the final legal hurdle and will be published in June, we have a 2-year period until the bulk of the AI Act comes into force in 2026 in June. And of course, companies need to start before June 26 to figure out how to be compliant. And therefore, if harmonized standards are the path, the easy path towards compliance, or the easiest path towards compliance, those have to be available at least half a year before June 2026. So right now in JTC 21, we're working towards getting those standards ready and published by Q4 25, which in turn means that the bulk of the technical work actually needs to conclude by the end of this year. This is followed by consultation and refinement and voting rounds. And I'd just like to give a big shout out to 2 people in the room. First of all, to Ansgar, who's moderating the panel, but also to Emilia Tanta, who I think is in the audience somewhere. They are leading one of the working group on operational aspects in JTC 21, which includes things like risk management. And I would like to point out that the success of JTC 21 is really down to the leadership of working group editors, project editors, working group conveners, task group conveners that lead in various ways to make the whole thing a success. And the other success factor is the ability for people and organizations to compromise, because the spectrum of opinions and the spectrum of interests in artificial intelligence is extremely broad. There are 140 people in JTC 21 as experts, representing 25 national committees. And if you count all the experts that are working within those national committees, commenting on, voting on, contributing from national perspectives, there's a total of between 1,000 and 2,000 people across Europe working on those standards and making it happen. So I'll pause there and hand it back to you, Ansgar.
Thank you very much, Sebastian. And just to slightly continue on the theme of standards and participation in them, just to point out that there will be a session after this one around the topic of increasing the participation in standardization work, and we will also be having a workshop on that theme after lunch. But I wanted to, before going to the audience for Q&A, I wanted to briefly give everyone on the panel a chance to perhaps reflect on something that they've heard from the other panel members, and maybe also to bring into that perhaps, if they feel like it, a reflection also. Is there perhaps some sectoral regulation space or some sector where work in direct sort of touching on the challenges that we're going to see now with AI has already been done or is being done in a way that could be inspirational for the broader thinking? And I could mention one or two, but I won't preempt what the panel wants to say. And I'll start off with Susan.
Well, I'm very struck by the word governance, because when I hear governance, I'm thinking the chairman and the board of the water company in the UK that is still systematically pumping tons of sewage into our rivers. So we come back to procurement. This huge gap between the world of the standard setters, the technical experts, and procurement. I hear procurement directors saying, I don't understand the standards. I don't understand what my suppliers are saying, but my in-house customers, the guys in HR, say it's okay. There's no real risk as far as procurement is concerned because the chief executive and the chairman don't know what questions to ask, which would give them the reassurance that actually they are complying or at the very least mitigating risk in a world where the risk as far as a procurement director is concerned isn't visible. I know you're really keen on solutions, Ansgar. I've been trying hard here. I do think we need to look upstream in the long run, because this is a long game. We need to change the way procurement people are trained. We need to get it right up into their training, just as we need to change the way HR are trained. So many key functions in these companies, they need to understand the implication of their particular functional deployment of this technology. Be alert to where the risks are possible, not just probable, because we're seeing unimagined risks, right? And a lot of risk assessment is what is probable. I think, too, we need to understand that much of what is unfair or damaging to the life chances of many marginalized groups is at an individual level, not the data group stuff. So you can argue this process seems to be safe for 80%, but actually for the individual who stammers and that AI tool only gives him 3 minutes for that interview, it's the individual who has been discriminated against. And how do you summon your data bias expertise around protecting that individual's right to an extra 15 seconds in that interview? I think, too, we're looking at what is acceptable risk is interesting. If it means I'm never going to get a job because I stammer, is that an acceptable level of risk? I'd really welcome your thoughts, Ashley, on what this word acceptable means. Because when we look around, you've got 1.5 billion people with disabilities, and somehow the risks to their life chances, their ability to access financial services, get life insurance, all the things that at the moment they're systematically really hindered from accessing, those risks don't seem to have penetrated the debate on ethical and responsible AI. So who out there is deciding where the risk lies? But I want to finish by just coming back to the word governance. Until boards have an understanding of the straightforward questions they can ask, and in terms of transparency, the reporting they need, because if the boards are given the detail that constantly permeates these discussions, when you look at the guidance that is around, there's no hope in heck that they're going to look at it. It's just not at all even feasible. But if you can ask 5 questions that would force the chief procurement officer to respond in the way we want him to respond, then perhaps there is hope. And I am encouraged by the European Commission's work on the Accessibility Act that's coming in. Procurement will be required to only purchase stuff that's accessible, and if they can't, or it won't, if they're going to say no, they have to be able to justify it. And I think then looking at the standards that apply to the justifications will be really important.
Thank you. Ashley?
Susan, so many things to say. And I think I'm going to try and structure my thoughts in a cohesive way, but forgive me if I do
mine,
not.
you mean?
Well, I think actually this is the point, that we're using words and we make this sound really easy, and Olga asked the question, who's read the EU AI Act? There's so much there, and many, many people in rooms that are talking about it, even sitting on panels talking about it, haven't necessarily read it, and that's problematic in its own right. But I think that, anyway, so to answer your question, though, around or commenting on things that are said, maybe I'll just start by responding to some of the things that Susan's just mentioned. which is back to what do we mean by some of these words that we're using, and that's why I'm saying that it seems like people have it all figured out, and it's easy, and it can be easy and simple, and in some circumstances, I think that it's possible, and there's many amazing people and many in this room that I know that are working on efforts to not only develop standards, but structures and testing and development processes to be able to simplify governance to be able to get to that objective. That said, I think this question of, or your reflection on what governance means to you, Susan, is a different thing than what it means to me, which is interesting in that I think about it I come from a background of data architecture, and so I think about governance as people, policies, and processes. And within that, there is a governance board. There are people that are ultimately accountable for making those decisions, but that's part of the structure that you need to set up in order to understand that. And reflecting then on the comment about the people and back to who is at the table making part of those decisions, we do need to include people that are part of the impacted communities for the application of AI that we're talking about. But I think that ultimately goes back to then the question of what is the AI that we're talking about, and therefore what standards do we need to create that are going to be followed by those people, the policies that are going to be set up to adhere to those processes, adhere to those policy objectives, and then the processes that are going to keep the accountability in that structure in place. And again, this makes it sound super simple, but there's a lot of complexities, as Olga was mentioning, in
That doesn't
whole
sound
supply
simple.
chain. Okay, well, it's super easy to say, like, people, policies, and processes, but it's not. There's a ton of nuance and depth and very, very intelligent people that have been working for a long time to go back to what I was saying even earlier, is build on existing practices and reflect on how can we augment some of our existing IT architectural review processes to be inclusive of now ethical evaluations. And you asked me the question of what's acceptable. So again, I would reflect on that for what. And when we identify in a common way the what, my sense, and I'd love to hear Sebastian's thoughts on this, is that Annex 3 of the EUAI Act where it classifies or it identifies different types of high-risk systems, will ultimately become the classification of the types, the categories of AI that we then need to develop standards and conformity assessments for, I would hope, in a systematic way. And then part of that can be to then have an international, there's a lot of interest in international harmonization through the work that Sebastian's doing, Ansgar, others, myself, on development of those technical standards for that legal certainty that Sebastian spoke to, that market interoperability, but we need to have a plan. And right now, I don't think we have a plan for standards, and a plan that's responding in a very simplified way to how do we get to those safeguards for people, policy, and processes. Anyway, sorry, that was a lot.
Thank you very much. Olga?
Yeah, thank you, Ansgar. I wanted to talk about this specific sector. We need to address our questions first, and this is not companies who are using AI as not a main service. It's not small company, not medium company. This is a big tech company, and I feel like regulating big tech companies is a bit of a game theory, because there is always a feeling that it will be a frame for innovation, and we should address that as well. And the second is that it's not all this regulation and how do we implement ethical AI is a lot about people, because we can have this top-down approach, thinking about regulation, thinking how we implement ethics, thinking about how we implement quality controls and all this stuff. But at the end of the day, who is taking all this decision? People who develop in the system, people who train the data set, who select the data for the models, who train the models, who are involved in all the AI life cycle. And there is a need to increase the awareness of the bias, of the fairness, of all these issues, and like allowing them to be more conscious about the decision they can make, just being not a small part of the system, but taking the responsibility fully.
Thank you. Sebastian?
Yeah, I would actually strongly agree with what Olga just said about the game theory view, or I would actually phrase it as we need to understand the incentive mechanisms that both organizations and individuals are under in order to make sure that regulation pushes the most effective levers. And ideally, we would strive towards an alignment of incentives and regulation, because then it becomes almost a no-brainer, and it becomes easier even for high-performance regulator. I very much like the phrase that you mentioned there, Susan, that even for high-performance regulators, it's a lot easier to enforce regulation. I think it's very, very important to recognize the point that Ashley, you made, that the AI Act is mostly concerned with specifying requirements for high-risk systems. And consequently, the harmonized standards that we're building in JTC 21 are mostly relevant for high-risk systems. And the question that companies and other organizations are asking is, well, what about the rest? And what about the question of how can we be competitive in the marketplace? So if we sell an AI product, it's not really enough to go to the prospective customer and say, hey, my product is compliant with the AI Act, because, well, the competition's product is hopefully also compliant with the AI Act. So it's necessary, but it's not a differentiator in the marketplace. So the question that companies are asking is, well, how can I be competitive as well? Or how can I prove that my product is fairer, more transparent, has better privacy protection, is more robust, is more explainable, is more accountable than the competition's product? And this in a way that goes beyond the requirements of the AI Act, so that maybe exceeds whatever the is needed for high-risk systems, or indeed that specifies those characteristics even for systems in the lower risk categories where the AI Act doesn't really demand that much. And so there is a whole raft of activities that's been going on for a number of years across Europe in order to define ways of complementing the AI Act and harmonized standards to kind of build out the overall ecosystem in a way that addresses both compliance and competitiveness in a reasonably consistent way, so that there are not two worlds, one world for becoming competitive and another world for becoming compliant, but rather to join up those efforts. And one of the concepts that has proven to be quite successful in that area is taking a leaf from something that everyone here in the room knows, and that's the energy efficiency label. So you have it on fridges, on dishwashers, on cars, on sometimes even on houses, on your vacuum cleaner, and so on. And those energy efficiency labels kind of look the same. You have a rating from A to G on your fridge. You also have a rating from A to G on your dishwasher. But underneath, there are very, very different technical specifications that describe what an A or an F or an D actually mean. And this has been a way of hiding a lot of complexity from consumers, but at the same time providing just sufficient granularity of information to the marketplace in this case, a B2C marketplace, so that consumers can make an educated choice whether they buy the A-rated expensive fridge for their kitchen or they buy the F-rated cheap fridge that just sits in the basement and cools the beer for a party twice a year. And we can take a similar approach to AI. There are applications where privacy is the top priority. There are other applications where fairness is the top priority, and we will always need to accept that there will be trade-offs, even between privacy and transparency. As soon as personal data is involved, you can't at the same time have maximum privacy and maximum transparency because you don't want to divulge training data sets. So you do need to make those trade-offs, and it's very important to allow customers and procurement departments actually to have the information to make those trade-offs. So looping back to the original point that we need an overall ecosystem with the AI Act in the center, surrounded by consistent frameworks, such as frameworks built on or inspired by the energy efficiency label. This is really what we're working towards, so that, yes, companies obviously have to conform to regulation, but they should be able to do so in a way that doesn't put them at odds with being successful in the market. Thank you.
Thank you very much, Sebastian, and thank you for picking up on providing an example of a space where something is already being done. With that, I'd like to open the floor for questions in the audience. I see we've got 3 questions in the back. The one all the way in the back seemed to have been the first.
Hi, Michael Veal from UCL. Sebastian said it's pretty much impossible for a company to be held non-compliant as long as they follow the standards. And the new legislative framework is really built on the idea you can separate out the technical from the political. You deal with the political in the legislative period, and you deal with the technical in the standards period. That is the entire basis. It's written into the Commission Blue Guide. That's literally what is written there. But we know there's absolutely no way that these Sentinel-X standards will deliver definite answers around accuracy, fairness, security, or the cultural aspects of data sources. Like, these are going to be based on assessments and judgments that are made by the entities applying the standards, right? So the standards will look like guides for assessments and trade-offs and impact assessments and so on. So the judgments of the company matter. But this means that companies end up acting out the process of assessment according to what the standard says. And standards have no good language of balancing or proportionality. That is not a concept that exists like it does in law inside standardization. It can't be scrutinized by courts and regulators. And furthermore, if you apply the standards, this presumption of conformity you get can't be challenged by the regulators in a very easy way. So are we not ending up in a position where, as Sebastian says, it's easy for high-performance regulators to enforce because the regulators don't actually do what they're supposed to do anymore. They're not able to ascertain the judgments, whether the judgments are made correctly by the companies, whether the assessments themselves are substantively, the results of them are worth the paper they're written on, and we're ending up laundering these subjective tests into some bullshit presumption of conformity.
Thank you. A challenging question. I'd like to collect the next 2 questions in the back as well, and then we'll take those 3 in one go.
Alex?
Yeah, I think it's okay.
Okay. Alex Leadis from the Future of Life Institute, and this one was for Susan, actually, circling back to your focus on the procurement link of the supply chain and how we must zero in on that. I wanted to hear a little bit more about what the role of checks and balances is for when the procurer is the government, given that our governments are often some of the biggest customers buying very high-risk AI systems with potentially catastrophic implications for people.
Okay, thank you. And then you one more.
Hi, Daniel Lufer from Access Now, and I'll add another layer of bullshit to Michael's. So, you know, in the best case scenario, you could see that the AI Act, the intention was to sort of set a minimum layer of standards for, you know, a basic regulatory floor for this very limited amount of high-risk applications, but there's all of the criticism even of that. But I don't know how many of you are aware about the loophole that was added into Article 6. It's in Article 6.3, which allows providers to derogate from the requirements for high-risk systems according to 4 absolutely enormously broad and vague criteria. So, you know, this was actually declared to be basically incompatible, to totally undermine legal certainty by the Parliament's legal service, but they just went ahead and put it in, and I think we're going to see this causing absolute nightmares for years to come. Because what it does is it introduces a mechanism whereby an unscrupulous provider can say, I'm going to take a shot here and opt for the derogation because, you know, it's going to be cheaper in the long run. We also risk that we'll have an absolute flood of these derogations. We do have minimal transparency about who derogates, but still it requires the regulators who are already overburdened, who lack technical capacity, to go after those companies, find out why they derogated, etc. So I'm wondering if, you know, the title of the panel being lessons from other sectors, do you have any insights into, I mean, from my perspective, this is going to cause an absolute nightmare. But I don't know if anyone could be more hopeful or have insights about how this could be tackled. Thanks.
Okay, thank you. I propose we go for these 3 questions. Who would like to start?
I'm happy to.
Okay, Ashley, if you're willing.
Really quickly, on the conformity assessments, I think, no, none of this is perfect. None of this is going to save all of the problems and challenges that we have. But I think that having some set of rules will ideally change some behavioral practices, and even having the conversations leading up to the EU AI Act, I've seen there be, or the work that I did in Canada, see that behavioral change. And this goes back to people saying that they're ethical. So again, having some consistency around what that actually means, I think, is part of having some of those processes in place will be useful. I don't think this is a hopeful answer necessarily, but what I would more specifically say is that this is exactly why we need people from impacted communities to be part of the standards development processes, but we also really need to have them be part of the governance review processes. And so I really hope that that is part of standards creation as we move forward. And I think we don't have time today to dig into some of the challenges with existing standards development processes, but I hope that they're recognizing some of the technical issues associated with these systems and the pace at which they're changing and the degree of harm that they can have. We also are able to adjust how we develop standards and create oversight mechanisms. And then also, I think it goes to the point that Susan was making earlier, which I should definitely mention, given that this is what our organization does, is provide appropriate training and certification for the people behind all of that work. So I think the point that was also being articulated is that if you don't have those appropriate rules, you're going to be dependent on the people that are overseeing them and interpreting those rules. And that's ultimately why I started doing the work that I'm doing now, recognizing that the work that Sebastian was talking about, creating a conformity assessment scheme for specific types of AI systems, has a lot of holes in it right now, and we're not mature enough to even define what those labels are going to be at the moment. But I'm still hopeful that that will be a helpful process and mechanism. Super quickly on the procurement, I know the question wasn't for me, but it was what we did in Canada. And actually, I would just direct you to look at what we did within the Government of Canada's procurement mechanisms. We thought through how recognizing that concept that we were a large purchaser, and so how we can put appropriate things like contract language into our procurement process, provide training for people that are going through that to understand what those implications are so that people could be asked the right questions.
Susan?
2 minutes or something we got, right? I would come back to the Department of Justice. When I hear governance, the word, I'm thinking of the chairman of the Department of Justice justifying not meeting their own legal obligations as a regulator. We need to understand how they justify that. And I'm very conscious of the board of the buyers, the Deutsche Bank, IKEA, right? How does the chairman of the board of IKEA know whether or not they are behaving properly? And they don't understand the standards. They wouldn't understand a thing, Ashley, you just said. They don't understand this at all. But there needs to be guidance at that level that says these are the questions. This is to alert you to potential harm to people, potential harm to your own employees, and the potential harm, of course, to your business. I do think the question of liability is important. The more we raise awareness at board level that you will, as IKEA's board, be held liable as well as Microsoft if they get it wrong, or the small IT supplier down the road in Singapore who's just persuaded you that this new way of assessing whether or not the personality of this candidate online meets what you want is actually any good. I love the phrase, the bullshit word, because NYU did some research recently. They looked at 2 packages HR are using to assess your personality and predict that personality to the recruiters based on your word choice in your word choice in your CV or your LinkedIn profile. And actually, Professor Yulia Stoyanovich rang me and said, it's bullshit science, Susan. It's a technical term I've learned is apparently part of your world. And what she's saying is your personality changed completely depending on whether or not they looked at your CV or they looked at your LinkedIn profile. Now, I don't know what kind of standard addresses that, but it's certainly not of interest to any HR directors out there at the moment, right? Because they've been taught that the technology is somehow on the market. The suppliers don't have to prove it's safe before they can sell it. And the HR people don't understand discrimination in this regard, so you've got market failure. And I guess I wanted to finish by saying we're actually interested in whether or not you've got a system where individuals can seek redress, because if individuals can't seek redress, doesn't matter. The unfairness will spread. And of course, we're interested in whether or not, in HR in particular, which has been our focus, the suppliers of HR products shouldn't be required to put hazard labels on. Just like when you buy aspirin, it has to list potential side effects. So when I buy this piece of kit, potential side effect is these individuals from these populations are likely to be at risk. They'll never get a job if you use this technology because you didn't look at the impact of visual impairment, autism, or whatever when you were designing this product. I like hazard labels. I've got some great ones designed with, skull and crossbones and stuff, to get the attention of the buyers. I'm not pretending for a minute that you would put hazard labels on these products, though I would be tempted to ask why not. But if I can get the buyers to go, what do you mean, hazard labels? Then maybe they'll start to think about the hazards, and they're not thinking about them yet at all. I like the fact that European legislation is talking about liability, because it has to be at the very least shared liability between the buyer, who has recklessly procured this stuff without looking into the damage it might cause, and the buyers who put it on the market without looking at the standards and so on that it should have adhered to. Thank you.
Thank you. Sebastian, Olga, do you also want to jump in on these questions? Go ahead, Sebastian.
Yeah, definitely. Just to strongly agree with Susan that quality and safety matter even if the product contains AI. And there is this weird trend that people somehow think that if a product contains AI, then all the usual safety and quality expectations and standards magically don't apply anymore because it's AI. And that's manifestly not true. And I share the concern that a lot of AI systems are being pushed onto the market that do not satisfy even the most basic expectations on quality and safety. But I'd like to come back to the first question from Michael Veal. And I think I also remember the paper that you published a few years ago analyzing the AI Act, or the initial draft of the AI Act, but also with a number of remarks on the standardization system. So what is standardization actually at its core? it's consensus building. So there's a very, very strong principle that in almost all steps of the standards creation process, the consensus principle applies. And it's not just the consensus of whoever happens to feel like participating, it's actually the consensus of all relevant stakeholders. So one of the explicit duties of the officers of any standardization committee, including myself as the chair, is to try everything to make sure that all relevant stakeholders are around the table. And for something like AI, that is a very, very broad range. There are a few mechanisms that help with it. So at the European level, there are so-called Annex 3 organizations for consumer concerns, trade union concerns, sustainability concerns, and small business concerns that automatically have a seat at the table, so that helps. But even beyond that, if I've got the impression that a particular stakeholder group is not represented, I at the very least have to make a strong effort to get them to the table and to participate. And this is really what standardization draws much of its legitimacy from, the combination of consensus principle and the obligation to include all relevant stakeholders. Now, there are obviously lots of practical difficulties here because different stakeholder groups have got different amounts of resources available. Part of the challenges that I'm facing chairing the standardization work is to try and somehow redress that imbalance of resources without losing impartiality. But as I said, that's basically where the legitimacy comes from. The second point to note in this context is that standards making committees and standards making bodies are not making the rules. So standards are there to fill in the box that is created by the legislator. So standards operate, in the case of AI standards, they operate within the box set by the AI Act. Now, we may disagree with certain aspects of the AI Act. There are people in JTC 21 who think certain aspects are too strict, and there are others who think certain aspects are too weak, or they should be different, or whatever. It doesn't matter in standardization. Those opinions are, of course, valid, but they do not lead to any possibility of standards somehow shifting the regulatory box or kind of undoing or modifying the political consensus that has been reached in the democratic institutions. So that's the second very, very important point. Finally, I very much like the concise risk that you flagged. I think you put it as laundering regulation through standards and other frameworks. This is a real risk, and many of the more heated discussions in JTC 21 are around the enforceability of standards. So is it enough for a standard to just show the way, almost like a best practice guide, or is a standard actually there to contain testable, enforceable, ideally even quantitative requirements? And that is one of the tensions that make consensus building sometimes tricky. But yeah, thanks for giving that a name. Cheers.
Okay, thank you very much. I'm afraid we've run out of time. I thank the audience for your participation and look forward to possibly seeing some of you also in the next session on the standards and the workshop on the standards. And I thank the panel members for their valuable contributions. With that, the session is closed. Thank you.
Thank you.